Thank you everyone for joining us today to talk about climate justice, examining recent developments. My name is Rachel Jean-Baptiste. I'm the Director of Publications and Communications here at the Environmental Law Institute. For those of you that don't know ELI or don't know us very well, please visit our website at eli.org, where you can learn about all the different ways we make law work better for people, places, and the planet. And be sure to visit the website often. For example, very soon we'll be posting information about ELI's work in environmental displacement and migration, an issue that might be of interest to many of the people attending today. But today we are talking about climate justice. And I wouldn't be doing my job if I didn't put in a plug for this book. We just published this a couple months ago. And from ELI members, as always, you get a 15% discount. Folks who are not members, we're offering a promo through the end of this month. Just enter CJ Seminar. It's good till the end of March. And we also have a couple of copies here available for sale today, also at a discounted rate. But the book itself, it analyzes, it looks at the concept of climate justice from a variety of legal and geographic perspectives. It draws upon 29 contributors from 16 different nations, and it offers proposed solutions to a variety of regulatory obstacles under international law, US law, and foreign domestic law. And so I'm really pleased that today we have, speaking on just a few of those topics, the editor of that book, as well as three of the contributing authors. Randall Abate, he's the Associate Dean for Academic Affairs and Professor of Law at Florida A&M College of Law. He's our moderator, and he's also the editor of the book. He's going to get everything started, but he'll also be talking a bit about atmospheric trust litigation. Next will be Maria Tigre. She's an environmental law attorney at the Cyrus R. Vance Center. She's going to be focusing on the global repercussions of the Dutch case Urgenda Foundation v. Netherlands. Next up will be Dr. Patricia Ferreira. She's a postdoctoral fellow from the Center of International Governance Innovation's International Law Research Program. She's going to be talking about the Paris Agreement and the concept of differentiation. And last but not least is Dr. Will Burns. He's going to be talking about the human rights dimensions of bioenergy with carbon capture and storage. He's the founding co-director for the Forum of Climate Engineering Assessment at the School of International Service, American University, and he's also a senior fellow at the Center for International Governance Innovation's International Law Research Program. And just one more bit of housekeeping before I let Randy get started. We want to have 15 minutes at the end of the presentation to Q&A. For those of you that are watching remotely, you can submit your questions via GoToWebinar. And for those of you that are watching us live via Climate Nexus, thanks for joining. I'm glad you could check this out. And so I will let you begin. Thanks.
Thank you. Thank you very much for that introduction, Rachel, and thank you all for being here. And those of you participating on webinar, it's great to see such a robust interest in this topic. This book project was truly a labor of love, working with all these experts from around the world on different aspects of what climate justice means. And today, as Rachel mentioned, today's panel is a snapshot of the coverage of the book to give you a sense of different ways in which climate justice has manifested itself in the courts and through international treaty negotiations and through international rights, international human rights frameworks. So I'm going to kick things off by talking about the litigation dimension of climate justice in the American court system, and then I'm going to be transitioning over to Maria to talk about climate justice and outside and foreign domestic courts, and then we're going to hear from Patricia and Will on other dimensions of climate justice outside the court system through international negotiations and international human rights. So I'm going to be talking primarily about a case that has really kind of drawn quite a bit of attention in the U.S. In an era where we're a bit depressed as environmental lawyers, seeing some overwhelming challenges on the horizon. One case has really brought a glimmer of hope to our cause, and that's the Juliana decision, which is an atmospheric trust case, which has survived a motion to dismiss and is set for trial in the U.S. District Court in the District of Oregon. And so I'm going to set the stage for how we got to atmospheric trust very briefly. This is a set of slides that I usually take about 30 minutes for, and I'm going to be breezing through in 15, but I want to give you a context for how we got to climate justice litigation in the U.S. and then more specifically atmospheric trust litigation. So to do that, we have to start from the proposition that environmental law used to be about environmental resources. It wasn't about humans so much. So the environmental justice context has to first be explored as something that put a human face on environmental regulation and environmental problems. And then how that transformed into the climate justice domain, and then more specifically the atmospheric trust litigation that we're seeing now. So that's kind of the overview of what I want to be covering here. So environmental justice, for those of you not familiar, it really took hold in the late 80s here in the U.S. We had a couple of decades of very successful environmental enforcement to protect resources, air, water, land, endangered species. And then ultimately there was an awareness that environmental problems go well beyond the integrity of the resources themselves. Environmental problems have human dimensions. And so this was initially brought to light through disproportionate impacts on minority communities, particularly African American communities, who were bearing an unfair burden of environmental problems compared to the majority population. And so this awareness of the human rights dimensions of environmental problems took on this lens of environmental justice as a way of thinking about environmental protection above and beyond the integrity of the resources themselves. So that field really took hold firmly in the 90s, kind of hit a big roadblock in the courts around 2000, where there was an effort to seek 14th Amendment protection for this disparate treatment that some communities were experiencing from environmental problems compared to others. And that didn't work in the courts. That was rejected. And so it fell off the radar a little bit for the next 10 years or so. Environmental justice then came to mean more about procedural protections. It didn't have so much of a substantive hold the way it was hoping to. But recently, the Flint, Michigan case and the disproportionate impact on minority communities and their drinking water supply really gave some new life to the environmental justice movement, and that was partnering at the same time that climate justice had already taken hold. So climate justice really took the lead from environmental justice, took the ball and ran with it. It was initially at the international human rights level. Regional, and I should say the Inter-American Human Rights Commission entertained a petition in 2005 involving the Inuit, an indigenous community located throughout the Arctic, U.S., Canada, and Russia, and so forth. And this indigenous community framed what came to be known as the climate change and human rights movement. It was the Inuit community alleged that there had been an impact to their human rights from the U.S.'s failure to become a party to the Kyoto Protocol. And so ultimately this case was brought to a commission which didn't have the ability to ultimately render a binding decision, but the amount of publicity and awareness building that this case brought to the international community about how the impacts to these indigenous peoples, how their loss of their right to be cold, as they called it, the melting in the Arctic caused by climate change, accelerated by the U.S.'s failure to regulate climate change, even though they didn't get any traction in terms of the international human rights domain for concrete relief. It brought a great deal of attention to the notion of what climate justice really means, how the legal system ought to have some way of recognizing the human rights impacts of climate change and how it's affecting marginalized communities like indigenous peoples and like low-lying island nations, for instance, which is another big piece that's addressed in the book. So that took hold domestically here in the U.S. through a well-known case called the Kivalina case in Alaska. And that case was filed shortly after the Inuit petition. And it was, I want to advance to this slide to show you where it fits in this continuum. So there was already a progression of cases in the U.S. courts that was framed on the basis of public nuisance. So initially, these claims were brought against major power plants throughout the U.S. An effort by states was brought to seek the major power plants to reduce their emissions, their carbon dioxide emissions from their operations by 20%. And collectively, these major power plants in the U.S. were responsible for a significant percentage of U.S. emissions. So the idea was we weren't getting what we wanted out of our participation in international treaty negotiations under Kyoto. We weren't getting federal legislation in the U.S. to address climate regulation. So we took to the courts. And so this was the first step in that effort of climate justice litigation to seek to use the judiciary as a way to get climate relief, climate change regulation, and initially it was just brought by states. That second block on the slides, then it went to affected communities. So victims of Hurricane Katrina brought a case based on public nuisance theory for the impacts they suffered from the intensity of Hurricane Katrina and how it displaced them and caused a great deal of harm and disruption. And the Kivalina case in Alaska was a part of this second step in these three stages on the slide. So the Kivalina case was a group of 400 Native Alaskans who lived on this narrow strip of land. It wasn't always that narrow. Sea level rise caused coastal erosion for their where they lived to be essentially uninhabitable. They're projected by the Army Corps of Engineers to only have about 10 years to live where they're currently located. And they brought a case against the 24 of the largest oil and gas companies, multinational companies, seeking to pay for their relocation costs. They were going to have to move only 10 miles away from where they currently lived, but out of harm's way so they would not be inundated because of their vulnerability on where they lived. And that case did not prevail in the courts. And that's something that I want to focus on in terms of climate justice litigation. Because when we move into atmospheric trust litigation, a lot of these same challenges are facing the current plaintiffs in atmospheric trust litigation that we've already seen in the initial waves of climate justice strategies. So these obstacles have plagued these plaintiffs, and they continue to be challenges. So the first one was federal displacement, and this refers to the fact that we have a Clean Air Act at the federal level, and the theory of federal displacement is that we shouldn't be using the common law system. We shouldn't be asking the judiciary to fashion remedies that could be obtained through Congress under existing legislation. So the Clean Air Act is the statute that would be leveraged to address climate change. And so the court's reasoning was, if we're going to afford climate justice relief, it ought to be through the Clean Air Act and not through some theory in the courts under our common law. So that was one ground on which the cases have been dismissed. Another, a common thorn in environmental plaintiff sides is standing. So standing has been a big concern, and particularly the causation element of standing has been a big problem for these cases. And then the political question doctrine was another challenge in the sense that these cases have involved using the court system to get climate justice relief. And the argument under political question doctrine is that Congress or the executive branch are better suited to address climate change and its related impacts, not the court system. And another related point is that the courts aren't equipped. Essentially, they don't have the competence to address these issues of climate change impacts due to their highly scientific nature. So how we got to atmospheric trust litigation is that it built on this momentum of the foundation of environmental justice, setting the stage of human rights and disproportionate impacts, and then these public nuisance suits that set a platform for the idea of climate justice relief in the courts. And then it was a retooling of our ancient public trust doctrine that was the foundation for atmospheric trust. So basically, this line of cases draws on the proposition that the public trust doctrine stands for the state as a steward of natural resources for the benefit of the public. So that was traditionally limited to the wet sands in coastal areas and the beds of rivers. Essentially, these resources could not be alienated and sold to private hands. The state had to manage these resources in a way that was for the benefit of the public. That gradually extended to reach other areas beyond those traditional the triad of uses, as they're called: fishing, navigation, and commerce. The courts eventually recognized that those public trust responsibilities in the state did extend to wetlands and wildlife, and it wasn't so limited. The public trust doctrine wasn't so narrow as it was originally formulated. And so it was building on that judicial expansion that atmospheric trust litigation steps in and says, why can't we extend the public trust doctrine to mandate the state to be a trustee of our atmospheric resources, to protect the integrity of the atmosphere for current and future generations' health and well-being? So that's the theory. And there were several cases that have been brought and are currently pending throughout the U.S. at both the federal and state levels. So the one that I want to draw attention to is the Juliana case. And in this photo, that's Kelsey Juliana on the left, and Olivia Trinac. She brought one of the cases in the state court cases. So what's unique about these cases is that they're brought by youth throughout the U.S., and they are representing current and future generations' interest in the integrity of the atmospheric resource system. And they're seeking to compel either state or federal government to regulate, number one, to regulate climate change in instances where they are not currently regulating, or two, to do a better job regulating climate change when they are only doing an initial effort and not going far enough. So it's really an ambitious use of the judiciary to seek to have this kind of relief against governmental entities. Traditionally, under environmental litigation, the most common citizen efforts for relief would be to seek to compel a governmental entity to execute a non-discretionary duty. So it's essentially something they had to do anyway, and citizens can sue to compel that responsibility. But this is a much more ambitious and creative use of a common law theory that's going on in atmospheric trust litigation. So there are a lot of these kinds of cases going on outside the U.S. So Maria's going to talk about some of those in foreign domestic courts after my remarks. What I want to draw your attention to is that the Juliana case was something that was almost surviving against impossible odds, that there's really a lot in this case. First of all, the fact that this case survived a motion to dismiss is a huge success, because the court acknowledged that there's not a standing concern, which has been a big challenge in these cases. There's not a political question doctrine concern, and this is also how it's getting to trial. But most significantly, the court acknowledged that there is a basis for the substantive claims that are being made here. So it's not just an extension of public trust to reach atmospheric resources that's in their substantive claims. They are also relying on constitutional arguments to allege that the government is essentially creating constitutional harms by failing to regulate climate change. They're alleging a due process, substantive due process basis for their claim, and they're also relying on the Ninth Amendment, which refers to those rights that aren't expressly enumerated. Doesn't mean they don't exist, and so there's opportunity for the judiciary to find new rights that aren't expressly conveyed in the Constitution. And so ultimately, what was most powerful about their reasoning was the reference to the Obergefell decision, a Supreme Court case on gay marriage that used very compelling language that you see in this slide, that essentially a stable climate system is so essential for the same reason that marriage is essential to our culture. It's a platform for the enjoyment of other very important rights to life and liberty. And so what's really exciting about this case is now it's set for trial. the federal government is quite concerned and is seeking to intervene to kind of tinker with how the case is going to be managed. I don't have the time to go into that at the moment, but it's really gaining a lot of attention and support. This theory and the prospects for success in this case. So I want to leave on a hopeful note in the sense that we've seen creative and persistent environmental litigation succeed in other contexts. So you don't have to think back too far in U.S. history to see industries that were seemingly untouchable and were winning case after case against environmental interests, and they eventually crumbled because of the creativity and persistence of environmental common law. Lead paint, asbestos, tobacco. You don't have to think too hard to think that the fossil fuel industry could easily be the next industry on this list to really take a big hit from this line of cases to essentially demand responsibility for climate regulation, both at the governmental level and at the private sector level. So ultimately, it's only meant, this atmospheric trust litigation theory is only meant to get one case at a time relief. It's not meant to be systematic, but ultimately it's supposed to motivate governmental responses that are more of a traditional top-down remedy. I've already gone over my time. Thank you for your attention, and Maria will take things forward with the foreign domestic courts and climate justice litigation.
Thank you, Randy. It's really a pleasure to collaborate in this book and to be here and discuss some of the core findings with you. Yes, sorry. So the focus of my presentation is on the famous Dutch case that I'm sure most of you have heard about, which reached a verdict at the end of 2015 and really changed the paradigm for climate change litigation. And I will cover Oh, I didn't get that now. Thank you. So I basically will divide my presentation in three parts. I wanted to give a little bit of background and already with apologies to those that already know a little bit more about the case, but I think it's important to discuss the claims that were brought and the decision that was reached. In the article, the book chapter that I should mention I co-wrote with Jennifer Huang, who's an international fellow at the Center for Climate and Energy Solutions. We discussed three of the legal implications that the case brought, and I will discuss one of those here today in the interest of time, and also some implications for future climate justice litigation. And as I discuss those topics, I will mention some other cases that have been brought up in some foreign courts. So Urgenda Foundation is an Amsterdam-based environmental NGO, means urgent agenda. And they, after 2 years of preparation, they brought this case along with almost 900 citizens, and they sued the Dutch states for its ongoing contribution to climate change at the end of 2013. And the action argued that the Dutch government was not doing enough to regulate and curb Dutch greenhouse gas emissions. So because of that, they were negligent towards its citizens. And they requested the government to cut emissions by at least 25 to 40% below 1990 levels by 2020. So the current goal is 16% from 2005 levels. And although the Netherlands is sort of a small country, it's actually a large emitter. It ranks fifth in the per capita carbon dioxide emissions, and is responsible for 0.5% of the world's emissions. So the claims were mostly based on Dutch civil law. There's an article in the Dutch Civil Code that addresses the violation of a personal right, a breach of statutory duty, or of an unwritten standard of care. And according to this article, the civil court may determine the applicability of the standard of duty, and because the government is not immune from liability under Dutch law, government agencies can actually be held liable as executive policymakers. So Urgenda claimed that the Dutch government violated this statute by not adopting more aggressive emission reduction policies that were needed to protect Dutch citizens. And they used the science from the IPCC reports to explain to give the facts behind global warming. They, in addition to the domestic law, they use the European human rights law and international environmental law to reinforce those claims. In particular, the objective of the UNFCCC and the long-term goal of limiting global warming to 2 degrees, as well as the preamble of the Cancun decision that says the developed country parties would have to reduce emissions in a range of 25 to 40% below 1990 levels if they wanted to avoid the worst impacts of climate change. So on June 24, 2015, the District Court of The Hague issued its decision in favor of Urgenda and rejected all of the state's defenses. In particular, a procedural issue that they addressed right away was that Urgenda actually had standing, which was in itself a big deal. And the court accepted Urgenda's claims that there was a breach of duty of care in this case, based on the precautionary principle, on the Netherlands' commitments under the UNFCCC, and also under the Treaty of the Functioning of the European Union itself. So they used international domestic law and the European Union law as well. So the court established that there was a legal duty to protect citizens from impacts of climate change, and that this duty was enforceable by the court. So should also mention that the court cited several components of international law, including the no harm rule, the doctrine of hazardous negligence, the principle of fairness, the precautionary principle, as I mentioned, and the sustainability principle. So they recognized that there was a partial responsibility of the Netherlands for contributions to climate change. So even though the Netherlands was obviously not responsible for climate change as a whole, it was partially responsible. And because of that, the court ordered the Dutch government to reduce greenhouse gas emissions by 25% below 1990 levels by 2020. In the aftermath, the Netherlands government formally filed an appeal. However, due to the procedural rules of the Dutch of the Netherlands, the decision is already enforceable. So the government had to start complying with it. So the case already had a huge impact on national policy making and public debate. A new climate bill has already been drafted. So really, even though the decision on the appeal is still pending, a lot of changes have already started to happen. So although the decision was really important and already made this huge change and inspired more litigation in other parts of the world, we analyzed three important legal issues that have significant implications, and I'll focus on one of those, which is the judicial overreach question. So a lot of scholars have debated whether the court's decision actually exceeds its judicial authority. Like several other systems around the world, the Dutch constitutional system consists of 3 branches, and it's supported by a system of checks and balances, in which each branch checks on the potential abuse of power by the other branch. So some argue that the decision is a threat to the rule of law and constitutional democracy, and opens the possibility of sort of an activist civil court, as they call it, which would then adjudicate science-based policymaking decisions by the government. It would not necessarily represent the majority of the population. So according to those that defend this position, this decision would likely be overruled by the Dutch Supreme Court, as the court cannot obligate the states to create new law. And this is according to the European Union law as well, which states that a national court may hold a state liable for any omission or failure to act where obligated, and also assess damages, but it cannot require states to act. And the second view that opposes this one is that the decision is actually restoring a constitutional balance. So because the government here was negligent towards citizens and didn't do enough to protect them, the court would actually be taking up the slack when the other branches of government have failed them and have not fully protected the fundamental rights that are guaranteed. And one of the problems with this position is that the decision was actually very precise and detailed, leaving the state with very few means as how to achieve it. So it's one of the weaknesses of this position. But the Dutch court actually addressed this issue in their decision, and they noted that there was a risk of intrusion into other areas reserved for the executive and legislative branches of government, but state that Urgenda was not prohibited from enforcing the government's duty of care in this particular case. So a similar issue was also raised by a decision by the court court in Pakistan in the Ashgar Lagari versus the Federation of Pakistan, which was a decision from 2015. This case was brought by a farmer due to the failure of the government to carry out the 2012 National Climate Policy and Framework, which was developed to implement the commitments under the UNFCCC. So according to the Bali Action Plan and the Cancun Agreements, the government of Pakistan had to establish some specific domestic climate change policies and implement them. And they established the policies in this 2012 policy framework, but they didn't fully implement it. So this farmer has alleged that climate change has led to water scarcity and temperature shifts, causing severe impacts in food security, and the lack of implementation of the framework actually worsened the scenario. And instead of asking for compensation, he actually requested the government to promote irrigation practices and green energy practices. And the Lahore High Court ruled that, first of all, that climate change significantly impacts communities in Pakistan. So it enforced the facts of climate change, put those in public record, which was in itself already a significant relevance in this case. And they said that the delay in implementing the framework has offended the constitutional rights to life, including the rights to a healthy and clean environment and the right to human dignity. So it based the decision on a blend of international climate change law and domestic constitutional norms, so directly linking climate change to human rights. As a result, they requested the government ministries to take specific actions to implement the framework. And the court in Pakistan was actually even more specific than the Dutch court and set up specific ways in which the executive branch would have to comply with the ruling. So the importance of both of those cases, Urgenda was obviously the first case in Europe in which human rights and international law have been used to determine a government's duty of care to its citizens with respect to climate change regulation. And the Pakistani case followed up on this, and it came from a developing world country, which is also a very significant importance for climate justice as a whole. So in those decisions, the courts really highlighted the obligations of the governments to protect its citizens, endorse the facts of climate change, making this public record as well, establish that climate change is real, that climate change is caused by human activity, that the impacts are worse and worse and dramatically impacting the world as a whole, and that the governments really should act. And they brought this human aspect to environmental law, like Randy mentioned, linking human rights with environmental law and climate change more specifically. So the Urgenda case already has some significant implications for other climate justice cases around the world. And I wanted to highlight three of those. The first one is in a case in Belgium, which was filed in 2015. And the motto is very similar to that of Urgenda. It was also a coalition of citizens that brought a suit against the federal and regional governments of Belgium for failure to reduce greenhouse gas emissions, and they asked the government to actually reduce by 40% by 2020, below 1990 levels. The other case that I wanted to mention, so the other two cases, the New Zealand case and the other case in Pakistan, the Rabar Bali, both of them are based on the intended nationally determined contributions, which were presented prior to the Paris Agreement. I won't go into a lot of details because I think Patricia's going to talk about that. But I'm sure, as all of you know, it was a bottoms-up approach in which developing countries could also set up their targets to contribute to reducing climate change and establish the ways in which they would reach those targets. And the nationally determined contributions, the NDCs, in itself already bring a lot of legal issues that may also be brought up by courts in the future. And these two cases specifically were brought up by citizens that were dissatisfied with the targets that were chosen that were set by their countries. So the New Zealand case was brought up by a law graduate, and she questioned the legality and the reasonableness of the government's domestic greenhouse gas emissions and the INDCs itself. So she requested a judicial review of the government's climate change policy. And in the Pakistan case, it was brought by a 7-year-old girl, also following this trend of youth cases brought in climate justice. And she also questioned the validity of the INDCs, but more specifically because of the lack of mitigation targets, mitigation measures, and also linked to a violation of the fundamental constitutional rights. So asked the court to rewrite the INDCs. There are several other cases that have been brought up, and we can discuss some of those in the Q&A if you're interested. There's a case in Nigeria, Norway, Switzerland, Philippines, South Africa, and Austria, just to give an example. But I think the gist here is that we are in a new era of climate action, and climate litigation provides ways in which the government and citizens can engage in a dialogue to increase regulatory ambition. So really broaden the participation and climate justice as non-government actors are pushing governments to do more when more climate action is urgently needed. And in a response to that, courts are actually starting to be more open to those initiatives. And I think courts are going beyond their traditional role. And it's something that is still under development, but the role of courts in climate justice is really changing, and the role of judges in particular is being redefined. So we're starting to play a more active role as well. And the third point that I wanted to conclude is that the Paris Agreement and the NDCs in particular bring an opportunity for more action that removes the focus on developed countries. So through the NDCs, it was this invitation for broader participation, and one that is tailored to the specific capacities of countries. And the key here, I think, is contribution and collaboration. So climate litigation has been one of those aspects in which to promote climate justice. There were several others that were mentioned throughout the book, and they were focused on that. And the key here is that the collective effort really should be according to all the countries' capacities, which I think is what Patricia is going to talk about. So I hope this was informative, and we can discuss more in the Q&A afterwards.
Thank you, Maria. In fact, I would like to start by saying that it's a great pleasure for me to be here to addressing the International Environmental Law. Oh, sorry, I forgot. Institute audience. I'd like to thank Randall for the great leadership in putting together a group of global contributors in this excellent book on climate justice. Rachel for her very efficient organization of this book launch, and my fellow presenters Will and Maria for their contributions. But my special thanks, of course, goes for all of you, both present here and in the via webinar, for your interest in participation in this discussion today. Often, when one thinks about climate justice, what first comes to mind are questions of remedies for those communities that are most affected by the impacts of climate change. Communities that tend to be the poorest and most marginalized communities, which least contributed to the climate change problem. Or also, we think about climate lawsuits against carbon majors or states, such as the ones discussed by Randall and by Maria. However, one of the earliest and most enduring debates on climate justice is the one addressing the problem of how to fairly allocate the burdens and the costs of climate action among countries that are extremely asymmetrical when it comes to A, their contributions to climate change, B, their financial and their technological capabilities to address the climate challenge, and C, their socioeconomic conditions or their development needs. And the principle of common but differentiated responsibilities and capabilities, or the principle of differentiation for short, has been at the center of this debate in the climate regime. And for a long time, this debate has been seen from a North against South perspective. Developing countries have accused developed countries of failing to assume their greater responsibilities to address climate change. Greater responsibilities because developed countries have historically emitted significantly more greenhouse gases, but also because developed countries have much greater financial and technological capacity to address or to act on climate. Developed countries, for their part, have argued that if left unchecked, growing emissions from emerging economies would derail their best efforts to address climate change. So in the chapter that I present today, I argued that this North versus South dimension or perspective became insufficient now to explain key recent developments in the climate regime, as exemplified by the evolution of the principle of differentiation. Before Paris, emerging economies such as Brazil, China, India, South Africa, they had promoted differentiation as a tool to promote climate justice, even if it sacrificed broad participation in the multilateral climate regime. In Paris, emerging economies have supported differentiation as an instrument to promote broad participation in the climate regime, while no longer promoting the principle as a main tool to secure climate justice. And here is a very quick roadmap of my presentation. First, I'm going to address the differentiation model of the 1990s at the United Nations Framework Convention on Climate Change, UNFCCC, and the Kyoto Protocol. Then I move towards the new model of differentiation, post-Copenhagen, that was reflected in the Paris Agreement. And then I'm going to talk about some of the implications for the way forward. So when the country signed the Framework Convention on Climate Change in 1992, there was this marked North versus South dissonance in the way that industrialized countries and developing countries consider the principle of differentiation. For the South, differentiation should primarily reflect the polluter pays principle, meaning that developed countries responsible for more historic and per capita emissions and having greater financial and technological capacity should pay the cost for climate action accordingly. The focus of developing countries was therefore strongly in corrective and distributive justice linked to respective contributions, capabilities, and development needs. Developed countries, however, accepted differentiated responsibilities to attract the participation of developing countries to global climate efforts, since they could not solve climate change unilaterally or only coordinating among themselves. So it was a trade-off or a balance between justice and participation considerations, a balance that had worked well in other multilateral environmental agreements, for example, the Montreal Protocol on the ozone layer, that gave developing countries longer periods to comply with their obligations, besides guaranteeing significant capacity building, financial assistance, and technology transfer to help compliance. But the model of differentiation embraced at the Framework Convention on Climate Change and the Kyoto Protocol was different. It made a very clear North against South distinction. Developed countries were called to take the lead on climate action by committing to mandatory economy-wide emissions cuts and by financing climate action in developing countries. All developing countries, including emerging economies, were given exemption of these central obligations and financial commitments, and instead of the facilitated compliance and capacity building that had prevailed in other multilateral environmental agreements. So the manifestation of differentiation in the climate system before Paris broke the balance between justice and participation considerations that had prevailed in other multilateral environmental agreements. First, we had the total absence of binding climate commitments by emerging economies. So if the primary objective of developed countries had been to use differentiation as a tool to enlist the meaningful participation of major developing countries, this did not happen in the climate regime. Then famously, the US rejected the terms of the Kyoto Protocol and never ratified the agreement. Canada withdrew from the Kyoto Protocol in 2012. Other countries such as Japan and Australia did not fully meet their targets. So this marked north versus south divide on differentiation was behind a gridlock that virtually froze effective multilateral climate negotiations for more than a decade. So to put this into an image, this strong emphasis on justice has in fact struck in the Kyoto Protocols, has sacrificed participation in the multilateral climate regime. The Kyoto Protocol ended up covering only 15% of global emissions which continue to grow significantly, especially in emerging economies. And the longer countries failed to reach a new consensus, the larger became the proportional contributions and capabilities of emerging economies. So indeed, just to illustrate this shift in the global asymmetries, in the 1990s, a small number of countries in the global north were responsible for 86% of the share of cumulative or historic carbon emissions, while all countries in the global south were responsible for only 14%. This is from 1850 to 1992. In 2010, however, emerging economies together were already responsible for a share of 35% of global emissions, while developed countries as a group were responsible for 33%. All other developing countries together were responsible for 32% of global emissions. We know that China has in fact now surpassed the US in terms of annual absolute emissions, but even in terms of cumulative of historic emissions, emerging economies as a group are responsible for a very significant share of global emissions, and they are fastly approaching the same levels of developed countries, even in historic emissions. The same shift is happening in terms of economic capabilities or financial capabilities. As an example, China now is the second economy in the world, and the emerging economies as a group, their share of the world GDP is convergent and is projected to in fact soon surpass the GDP share of developed countries as a group. But if we look as well to technological capacities or capabilities, it's true that in 1992, when the Framework Convention was signed, developed countries concentrated most of the world's technological capacity. But this situation has also changed. In 2011, the World Bank has commissioned a global index, a global index of scientific and technological capacity, and the findings have defied the common perception about the limitations of technological capacity in developing countries. China has climbed from 38th place in the ranking in 2001 to the 3rd place in 2011. India from 44 to 12. Brazil from 39 to 16, and even South Africa from 43 to 37 place is still within what's called the technological proficient group, along with many developed countries. Now, let me be clear here that it's true that emerging economies cannot be placed in the same category as developed countries due to their development needs, and also because there is still lower per capita and historic contributions, which Maria mentioned. But it's also true that based on the polluter pays principle and the capabilities idea, they will have to accept a meaningful share of climate obligations, one that is differentiated from other developing countries, which have much lower contributions, much lower capacity, and much greater development needs. So the outcome of the climate negotiations could have been, for example, the creation of a spectrum of obligations or a new category for emerging economies with a different set of obligations, but this is not exactly what happened. We know that the fortune of the multilateral climate regime, changed in the late 2000s, air pollution caused by the same carbon emissions responsible for climate change became a public health and a political chicken bomb in China. In the US, we had Barack Obama elected president, making climate change one of his foreign affairs and domestic priorities. So the interest of the two largest greenhouse gas emitters, one in the global north, one in the global south, had finally aligned. In 2009 in Copenhagen, despite the failure to arrive at a new binding climate agreement, the group of emerging economies and the US finally agreed on a path forward for climate action post-2020. And this alignment has enabled this broader global consensus on the need and the opportunity to move the multilateral climate regime forward. So what we have witnessed was a critical juncture that led to the successful negotiation of the 2015 Paris Climate Agreement. The Paris Agreement has many strengths and has many limitations, as you all surely know. But one of those limitations that I'm highlighting here today is exactly that the climate justice aspect related to the allocation of responsibilities among countries is not there in the Paris Agreement. When one looks closer, this link between contributions to climate change, capabilities, and climate obligations was not reflected in the text of the Paris Agreement. So the Paris Agreement now has established a hybrid regime. On one side, you have a set of universal, non-differentiated obligations. You have, for example, common legally binding obligations to prepare and to communicate periodically nationally determined contributions. The reporting is mandatory, but the substance of the commitments is voluntary now for both developed countries, emerging economies, and all developing countries, in fact. There is also a common transparency framework and a common compliance regime, which is facilitated to all countries. But recognizing the normative legacy of the Framework Convention, the Paris Agreement has maintained some elements of the North versus South elements of differentiation. Developed countries still expressly will take the lead with economy-wide emission reduction targets. Developed countries shall provide financial resources for developing countries to take climate action, and developed countries shall provide capacity building and technology transfer to the developing countries. So this model has allowed virtual universal participation in the Paris Agreement, which has been broadly considered a diplomatic success. What the Paris Agreement did not do was to expressly establish an intermediary set of legal responsibilities or obligations for emerging economies, one based on their greater contributions and their greater capabilities and the lesser development needs when compared to other developing countries. So again, to put this into an image, the strong emphasis on participation meant a sacrifice of the earlier goal to use differentiation to promote climate justice. So what are the main takeaways? As the contributions and capabilities of emerging economies grew over time, significantly when compared to other developing countries, they have changed their position on differentiation, favoring a shift from a justice perspective or a justice approach to differentiation from a more pragmatic approach to differentiation, emphasizing participation. As neatly described by Lavanya Rajamani, who is the leading expert on differentiation in international environmental law, and I quote her, "The climate differentiation, once inspired by principle, is now firmly in the realm of practical politics," end of quote. So it was this shift in the position of emerging economies that has led to this transformation of the principle of differentiation in the climate regime. Other takeaways. We are now farther away then from this idea of climate justice as this correlation between contributions to climate change, capabilities to act on climate, and international climate obligations. But there is a silver lining that the Paris Agreement has included some innovative institutional features such as a strong transparency framework and periodic stock taking. And those may serve as instruments to apply political pressure to push both developed countries and emerging economies to face or to embrace their stronger or the greater climate responsibilities. But how exactly this will play out, we still do not know, as it will depend on many variables. And one variable is exactly the question whether we can keep the momentum on the multilateral climate regime. We now know that this rare global political consensus on climate action did not last long, unfortunately. Only 1 year after the signature of the Paris Agreement, we had the election here in the US, and now a climate denier is in the White House. So the new administration has promised to protect coal and oil jobs in detriment of the global climate regime. And as we stand here today, US climate action advocates are again bracing for a new wave of climate litigation, which is one of the other avenues for climate justice. On the flip side, China, India, Brazil are still on board on the climate regime, and they may play a much bigger role globally with other developed countries. So what this study shows is that no matter what happens in the US and other developed countries, this old North versus South divide or perspective is no longer sufficient to explain recent evolutions of international environmental law, and this was really exemplified by the evolution of the principle of differentiation. So if this change was for good or for bad, I think that only time will tell. There is no consensus in the literature whether binding legal international obligations are more fit to change state behavior, for example, than soft cooperative instruments. What is certain is that participation and not justice has been the primary driver of the new differentiation in the Paris Agreement. So seeking climate justice will depend a lot more on other provisions seeking to protect against the human rights violations related to climate change, for example, and to the response to climate change, which is going to be the topic of Wilburn's presentation. And I'm happy to take your questions in the Q&A.
Okay. Thank you very much, Randall and ELI, for inviting me. I know we're running out of time, so I'm going to try to do this quickly so that there's some time for questions also. So in the past decade, there's been substantial focus at the international level on the nexus of human rights and climate change. And most of this emphasis during this time has been on the potential impacts on human rights of climate change itself. However, if one looks at the Paris Agreement and its preambular language that addresses human rights, we see a transformation. Instead of an emphasis on the potential impacts on human rights of climatic impacts, rather there is an emphasis on the potential impacts of responses to climate change, including mitigation and adaptation. However, in this preambular language, there's really no evidence of how one would operationalize that language in a way to protect those human rights in terms of response measures. So the purpose of my chapter was to present a framework for operationalizing the Paris Agreement's human rights language in the context of response measures by focusing on an emerging form of climate mitigation characterized as bioenergy and carbon capture and storage, or BECCS. BECCS seeks to reduce concentrations of carbon dioxide in the atmosphere by using carbon-storing feedstocks to produce heat, electricity, as well as liquid and gas fuels, coupled with carbon capture and sequestration, a process that captures carbon and seeks to store it either terrestrially or in the world's oceans. BECCS itself is denominated as a negative emissions technology because it can, at least in theory, effectuate a permanent net removal of carbon dioxide as opposed to options that merely reduce emissions in the atmosphere. While there's only a handful of BECCS projects currently, 87% of the integrated assessment models of the IPCC's fifth assessment report that provide paths to hold temperatures to below 2 degrees Celsius, the Paris target, contemplate wide-scale deployment of BECCS, perhaps as much as 10 gigatons a year in terms of total capture. And indeed, Paris would seem to provide authorization for BECCS and other carbon dioxide removal processes by indicating that one of the components of mitigation is enhancement of sinks of this method. Yet while BECCS could prove to be an important component of addressing climate change, it also potentially poses serious threats to human rights in terms of some of the world's most vulnerable people. And in my chapter, I argue that the use of a human rights-based approach could be an effective way to operationalize Paris's human rights language and to help protect all relevant interests. And so in this presentation, I'd like to briefly, first of all, look at the potential human rights ramifications of large-scale deployment of bioenergy and carbon capture and storage. And second of all, briefly outline a human rights-based approach and how it might seek to ameliorate any potential impacts on human rights that large-scale deployment of BECCS might effectuate. So first of all, in terms of BECCS and potential impacts on human rights, there are several that could potentially occur. The first of these is in the context of the right to food. As we all know, the right to adequate food is established by a number of human rights instruments, both at the international level and at the regional levels. However, deployment, large-scale deployment of BECCS could contravene this right in several ways. First of all, large-scale deployment of BECCS could require diversion of agricultural land for bioenergy feedstock that could substantially raise food prices. Even delivery of a relatively modest 3 gigatons of negative emissions from BECCS would require a land area of approximately 380 to 700 million hectares of land, which translates into 7 to 25% of agricultural land and at a whopping 25 to 46% of arable and permanent crop area. Several recent studies have indicated that large-scale BECCS could result in a net decrease in calories for some of the world's most vulnerable populations because it could result in massive increases in food prices. One recent study in the journal Nature indicated that BECCS, even at the level of 5 gigatons a year, could raise food prices by as much as 25 to 30%. And for vulnerable populations, which often expend as much as 75 to 80% of their income on food, this could prove devastating. And we've seen empirical evidence of this when in 2007, the European Union modestly increased its biofuels demands, and it resulted in a substantial spike in food prices and food riots throughout the world. BECCS would be that biofuels commitment on steroids. Second of all, BECCS could potentially contravene the right to water. The right to water is recognized in several conventions. Moreover, the United Nations General Assembly recognized this right in a resolution in 2010. BECCS could imperil the right to water. By 2100, BECCS feedstock production at scale would require approximately 10% of the current evapotranspiration from all global cropland areas. To put this in context, it would be the same magnitude of water withdrawals as all current total agricultural water withdrawals. This could strain already severely limited water resources for millions. It could reduce crop potential, especially in most vulnerable areas, and it could also substantially increase water degradation in many regions of the world, including Africa and South America. Moreover, BECCS could contravene the right to health. The right to health, again, is recognized widely in international law, and BECCS could undermine this right in several ways. First of all, it could result in substantial diminution of biodiversity through habitat destruction associated with carving out large areas of land for feedstocks, including both forests and arable croplands. Recent studies indicated that the impact of BECCS in terms of biodiversity could be equivalent to raising temperatures by 2.8 degrees Celsius by 2100. Loss of biodiversity could undermine the right to health by leading to an increase in the transmission of infectious disease by increasing the viability of vectors. And this could include substantial increases in diseases such as hantavirus, Lyme disease, and others. It could also undermine health in terms of water contamination, as described above. And finally, BECCS could potentially undermine the human rights to subsistence, which are recognized under international law. And BECCS could do this in several ways. First of all, it could result in huge land grabs, as has already occurred in many contexts in the association of biofuel plantations in areas such as Africa and South America, driven largely by European demand and U.S. demands for biofuels. We've also seen similar land grabs, often extra-legally, in the context of REDs. And it is likely that these would substantially escalate given the huge demands for feedstocks that BECCS at a level of 5 to 10 gigatons would entail. This could undermine vulnerable populations who rely on such lands for economic subsistence, especially forestry resources. Moreover, diminution of biodiversity associated with the use of BECCS would deny vulnerable populations critical resources that they rely on in terms of their livelihoods. So on a number of different axes, large-scale deployment of this new technology potentially threatens human rights. The question is there a way to connect the rather vague human rights language in the preamble of the Paris Agreement with substantive measures that would ensure that these human rights are recognized and that BECCS, if indeed it needs to be deployed to protect the world's climates in the futures, are done in a way that we seek to ameliorate any potential adverse impacts in terms of human rights. And what I argue in the book is that we could potentially do this through the development of a human rights-based assessment network. My chapter in the book argues that the mandate of the Paris Agreement could be operationalized by using this human rights-based approach. The hallmarks of the human rights-based approach are several. First of all, there's a focus on the relationship between the rights holders and the duty bearers. Second of all, there's an identification of gaps in terms of legislation, institutions, policies, and resources that are necessary to ensure recognition and protection of human rights with the deployment of new technologies or processes. And third of all, there is the possibility that the most vulnerable will have the ability to influence decisions that potentially have impacts on their lives, including their human rights. The human rights-based approach has been embraced to date by international, national, and subnational governmental and non-governmental organizations in a wide array of contexts, including health, development, and environmental protection. And drawing on these guidelines, especially from the human rights and development institutions, I argue in the chapter that applying the human rights-based approach to consideration of BECCS should utilize three essential elements. First of all, identification of human rights claims of right holders and corresponding human rights obligations of duty bearers. And several things would be critical here. First of all, it would be critical to recognize who the rights holders are. And this would include not only those whose potential human rights would be impacted by domestic deployment of BECCS, but also those that might be impacted in a transboundary context by the deployment of BECCS, especially in the context of food prices, as discussed above. Second of all, it would be critical to recognize all of the potential duty bearers, both those that are domestic as well as those that would be benefiting from BECCS internationally. For example, parties under the Paris Agreement that might seek to partially meet their NDC commitments through the use of bioenergy technology should be recognized as rights holders, whether the BECCS is deployed in their country or in another country in which they rely on those resources. Also, there would be a need to comprehensively characterize the human rights that are potentially contravened by BECCS and their sources, again, both in terms of domestic law and international law. The second component that's critical would be assessment of the capacity of rights holders to claim their rights and of duty bearers to fulfill their obligations. One of the things that we know in the context of bioenergy is there is a very large gap in terms of assessment, in terms of potential impacts of bioenergy deployment in the environmental context and the socioeconomic context. This would require substantial devotion of resources to accurately assessing those potential impacts and mapping them over the course of the world's most vulnerable populations. That is something that should be done before any consideration of large-scale use of BECCS happens, and it should be incorporated into current pilot projects to help us to develop a sense before we scale up the use of these technologies in the future. Third of all, we need prioritization of the rights of the most vulnerable groups and individuals. This should include not necessarily focusing on the cheapest route to BECS development, which may be the use of food crops for feedstocks, as well as the use of virgin forests. Instead, there should be substantial increases in research and development in things such as lignocellulosic and algae-based biofuels that would reduce potential impacts in terms of food and forest resources. While these paths may be more expensive than utilizing virgin land, they would recognize the need to potentially ameliorate human rights impacts in terms of the world's most vulnerable populations. Moreover, there should be an emphasis on not developing BECS projects in so-called failing states, where elites may not be interested in protecting the rights of the most vulnerable. This is particularly important in the context of BECS because a recent study in the journal Science indicated that 45 to 50% of the potential land areas for biofuel feedstocks would be in failing states. To simply cut agreements with the elites in those countries would fly in the face of the protection of human rights of the world's most vulnerable populations. And then finally, there is a need for monitoring and evaluation of outcomes in terms of human rights. This requires several things. This requires a human rights impact assessment process, and similar to that would be utilized in an environmental impact assessment process. And indeed, to the extent that virtually all of these projects would require EIAs, a human rights assessment process could be folded into this process to increase efficiencies and benefit from some of the common themes between those two. Moreover, it would be critical to have ongoing monitoring of these processes to ensure that human rights are not contravened in the future. And so, in summary, we may reach a point where indeed we need to look at what we now characterize as climate geoengineering options, given the feckless response of the world's community to climate change. But one of the things that we should try to do is avoid what has happened to date, which is visiting the most serious impacts of climate change on the world's most vulnerable. Every effort must be made to ensure that the world's most vulnerable do not suffer commensurately in terms of our responses to climate change. BECS provides us with a good case study in developing a framework that will help ensure that this does not happen, and potentially is a way to put meat on the bones of the Paris Agreement's human rights obligations. Thank you very much.
Thank you very much. And we have 10 minutes left, but I'm told that we're able to keep the webinar line open a little bit so we can get the full 15 minutes of questions. I guess we'll go ahead and start. If anybody had a question in the audience. Yes, sorry, right there. Great.
So Lee Paddock from George Washington University Law School, and I've got a brief question for Andy and for Will, for Randy. Randy, I understand the Justice Department is thinking about trying to find a way to get the Giuliani case in the Ninth Circuit Court of Appeals. I wondered if you might comment on the possibilities there. And Will, in the case of biofuels, it gets a lot of play in climate, but it seems to me that for a long time we've recognized that the use of land for biofuels is going to be very problematic. And I'm wondering whether we should just de-emphasize biofuels in relationship to wind and solar and perhaps other forms of renewable energy.
So I'll respond briefly to the first question. I just became aware of this development last night, so I don't have a whole lot to say. But overall, I'm encouraged by the response. I think it shows that the government is sufficiently concerned about the potential viability of this case. The extensive discovery and information that will come out to support the plaintiff's case is quite destructive to the government's interest in refraining from regulation, and destructive to the fossil fuel industry's interest in maintaining a protective veil on essentially what they're doing and not being accountable. So I think there's a lot more that I look forward to learning about in terms of the nature of this, because it appears a bit unusual to request the appellate court to kind of intervene before a case is going to trial at the district court. So I'm at least encouraged by the fact that the government looks scared.
So in reference to the question of de-emphasizing biofuels, a couple of things. A lot of it depends on how quickly you assume that you can increase market penetration in terms of renewables, right? In the IPCC and integrated assessment models, there were 116 of them that met the 2C goal. All of them contemplated substantially escalating the use of renewables and in fairly optimistic ways in some cases, but none of them, or 104 of the 116, could not get to holding temperatures to below 2 degrees Celsius, much less well below 2 degrees Celsius, and certainly not 1.5 without substantial use of these negative emissions technologies, simply because of the huge buildup and the inertia of the system. And, you know, I have some sympathy to this. If you look at where we are in terms of the NDCs, right? If all of the current NDCs are implemented absolutely faithfully, we go from 48 gigatons a year of carbon to 55 by the year 2030, right? We're still going in the wrong direction. And that includes assumptions of substantial increases in uses of renewable energy, right? If we are going to take biofuels off the table or other kinds of negative emissions technologies, we're really going to have to massively commit to renewables in ways that maybe we just won't. I think one of the things that we should be looking at in terms of negative emissions technology is funding research and development with some of the other forms of negative emissions technologies that would be more benign. There's something called direct air capture. This use of these ugly things called artificial trees that essentially use large filters to suck in the ambient air, separate out the carbon dioxide, and then store it. Those do not require these huge uses of land, huge uses of water, etc. Those potentially might make sense, as could some of the other forms. And right now we're not funding those virtually at all. The real worry, I think, with BECCS is because the IPC assumptions are really baking in an assumption that we're going to have 10 gigatons of BECCS. If we're not going to do that, if we're going to make a conclusion of society that from a socioeconomic, a justice perspective, that that's not viable, we really need to be making that decision now and escalating commitments to renewables, as I think you'd suggest.
Carol Excel from the World Resources Institute. I'm interested in a little bit about the strategy behind an atmospheric trust case versus a case that relies on NDC or policy implementation. And do you in your studies of both of the cases that took these different approaches, do you understand the pros and cons of taking one versus the other, a kind of constitutional approach versus a policy implementation? If you could speak a little bit more about which one was relevant in which case and why you think they took that approach.
I'll start by saying that the constitutional approach is clearly not the easy path to success, and so I think that's a function of the challenge that we face in the U.S. That we have to be more ambitious with our legal theories, more creative, more persistent, and I think that's certainly something that offers some potential for success, however, because outside the environmental context, we do have a tradition of judicial precedent that was essentially judge-made evolution of constitutional rights and values that certainly were not in the original Constitution. So there's some leverage there for it to be possible, but because we have nothing and we're trying to create something in terms of a government response, the legal theories have to be more ambitious. I think the NDC approach is certainly more viable for more short-term success because it's essentially seeking to either enforce what's currently not being enforced or enhance what's not being enforced well enough. And I think Maria can speak more to that.
Yes, from the foreign courts perspective, I can say a lot about the strategy behind it, because I really don't know why they decided to go one way or the other. But I think now we have, let's say, maybe 3 different ways in which the climate justice litigation is moving forward in some of the countries. So the constitutional approach would be one of those, and I think in that case, there's I guess the goal there would be to directly link climate change to the human rights aspect of that as well, which I think in terms of a long-term approach, long-term goal is better. And like Randy said, the sort of the policy implementation and the ones that are questioning the NDCs, it's more short-term, and it's, but in a sense maybe a little easier because it's like you said, it's trying to enhance something that is already there. So either a law or a policy framework that has already been agreed on by the government. So we're just trying to improve what already exists. And I think that the third sort of trend of cases is they're trying to target specific projects as well. So there was some 2 decisions in the last month, I think, one in Austria and the other in South Africa, in which they used climate change arguments to sort of halt specific private projects, and they succeeded in that as well. So it's another approach that seems to be sort of changing to the courts or being more open to that as well.
May I add one quick thing about this question? Question about policy versus judicial approaches, for example. I think, as Will mentioned, we are still so far away from the targets than what we need to do, right? So we need all of the above, and there is so far that the courts can do. In fact, if the executive and legislative in key countries are not active enough, right? So I believe that if you think about this thing strategically, you have to use all tools that are at your disposal. So the strategy has to be a multi-pronged one. And also it's very fluid. So you had in the US like a few years of a more proactive executive, and now you have the opposite. You had emerging economies trying to drag their feet in terms of assuming more responsibilities, and now you have China becoming a new leader in global climate action. So it really, you have to be flexible as well with those strategies.
Hi, so this pertains to the question of historical cumulative emissions. I think, and correct me if I'm wrong, that the numbers you were using were derived by site of pollution, which is the standard way to do it and relatively straightforward. Arguably, in a transboundary context, when you're applying polluter pays, it makes sense to move some of the bill with a good for export whose economic benefit is going to a receiving country, which is, of course, much harder to do. I recall some work on this accounting method 6 or 7 years ago. Is that an active part of the discussion on historical responsibility now? And is it even a useful point to try to make in the present negotiating circumstances?
I think it is a very interesting question because, in fact, how to account is a huge challenge still, right? And there are many attempts. For example, the Meteorological Association is trying to find ways also to check what the countries are reporting in terms of their own emissions, but there are all those challenges that you mentioned, and who should pay the bill. There are questions of trade and carbon adjustments if you're going to price carbon. So those are very thorny questions. At the global level, in the negotiations, in the end, it ends up being a political, like a compromise of what exactly countries will accept to do, right? So right now, all those questions have been put aside in a way, but they always pop up again in each and every negotiation. So we are going to see that again now in June in Bonn in the intersessional meetings. We're going to see that again in Bonn, but again, at the end of the year, the Conference of Parties 23 is going to be in Bonn, but it is organized by Fiji. And people are expecting all those issues to come up again. But the best resource to look for the state of these discussions is the IPCC reports, because they do include lots of very technical discussions and questions, and the state of the art of discussions on accounting of carbon emissions and on this distribution as well. But I would say that in the end, those thorny issues have been put aside for the time being.
I think we have time for maybe one more question or any last comments. Yes.
Thank you all very much. My question is related to permanent relocation as a climate adaptation strategy that many nations and communities are facing, and there are a lot of climate justice implications with that. And to my knowledge, there hasn't been a lot of litigation around this issue except for maybe the Kivalina v. Exxon lawsuit to try and get damages to help with the relocation process, and of course that wasn't successful. So my question is, have any of you thought about like that balance between policy, legal pathways forward to help some of these nations and communities get the resources that they need in a way that protects a lot of their cultural indigenous practices and human rights?
Yes. I think one potential mechanism that's underutilized at this point, and hopefully will be utilized more, is the loss and damage provision of the Paris Agreement, Article 8. Article 8 contemplates looking at needs for permanent relocation, efforts to privilege keeping people within their countries and protecting economic and cultural patrimony and establishing funding mechanisms to ensure that that happens. I would strongly encourage developing countries to hold developed countries' feet to the fire in that context, because one of the things that they did was they essentially gave away their right to claim liability for damages associated with climate change in exchange for this provision. And if the provision means nothing, it certainly should be focusing on issues of that sort. Whether it will or not is a different question, but there is a formal mechanism, and there's a review coming up in terms of the adequacy of those measures and what other measures could be taken in the future.
First, I would say there are three very good chapters in the book that address this on varying levels. And secondly, I'm going to be giving a talk on climate refugees in 45 minutes at Beverage and Diamond here downtown, so you can follow me over. But this is a huge issue, and it's got major human rights implications. And I think one of the biggest challenges right now is kind of the term refugees is creating some baggage. So the idea of the climate displaced kind of falls in the void between international environmental protections and international human rights protections. That the notion of climate refugees doesn't fit the current definition of refugee in the Refugee Convention. And as Will noted, there's just nothing in the way of the Paris Agreement's approach to expressly embrace the rights of the climate displaced. So really, it seems like the best short-term solution is international funding mechanisms. So we have the Green Climate Fund. It's not quite where it needs to be in terms of robust financial grounding, but ultimately, to the extent we are sending large sums of money, estimated at $100 billion per year is what it's supposed to be, to the extent that that is flowing from developed to developing world, I think part of it could be earmarked for climate relocation in developing countries, and it's likely to take place on more of a regional focus level instead of global to global kind of support to relief. So I think we're going to see hotspots of climate refugee issues, certainly in the South Pacific and the Arctic, and there might be some regional frameworks that could be built up that would be much more effective than some kind of international climate refugee treaty, which would take a decade or more to operationalize. So it's really kind of a patchwork right now and not happening fast enough.
Okay, well, I just thank you, speakers, and thank you all for joining us.